Okay, second part of the video here. On slide 11, I give you sort of a little question guidance to kind of how do you think through these things? How does the court think through these things? So a seizure in this case is so you go, what is an arrest? What is a search? What is a seizure? Right? So a seizure and an arrest are kind of the same thing. I guess a seizure or arrest is a seizure of a person by the police. And then, of course, seizure of an item, a thing, evidence, also, of course, by the police or by the government, rather. So if there is no seizure, then there is no Fourth Amendment. So, for example, when you get pulled over in your police car, or excuse me, when you get pulled over for a ticket, that stop is a Fourth Amendment issue because you've been detained, right? So that's not an arrest. Now, they have probable cause because they've maybe clocked you on a radar at breaking the speed limit, or they have noticed, or it looks like maybe you're not wearing a seatbelt, or it looks like your brake light is out, or whatever. So they have a reasonable suspicion or a probable cause to stop you. But you've not been arrested, right? So you don't get they don't have to have a warrant to pull you over. If they've just sort of walked by and looked in your car, the glass through the parking lot, they can go through and look at your car. They can't like open your door, roll down your windows and all that, but they can look in car windows and, hey, we're looking for this or that, go through the mall parking lot or up and down the curb on a public road. They can look at your license plate, obviously, right? You have to display a license plate. They can look at the outside of your house. Those aren't searches, so therefore there's no Fourth Amendment issue for that. And then the good general rule is if the more intrusive it is, as I mentioned in the last video, the more protection you get. So asking questions, not intrusive at all. Like, hey, how are you doing? Now, once you've been arrested, that's called interrogation. But if they're just asking you a question like, hey, did you see anything? Or do you mind if I talk to you for a couple minutes about this incident? And you're a witness but not a suspect, those kinds of things. It might be intrusive to your time. You might personally feel it's intrusive, but as a legal matter, the court's not going to go, oh my gosh, they can't talk to anybody without probable cause. That's not the standard. And then obviously things like surgery to get a bullet out, against your will, which could be evidence, or a toxicology report, or those kinds of things. They're going to have probable cause justification for those kinds of things. The word reasonable has oftentimes is often used in here as well. We talked about reasonable suspicion, reasonable person. So a reasonable person is what a juror is going to be considered your average reasonable person. What would an average normal person think about X, Y, or Z in this case? So when you're arrested, in the seizure of a person, the general rule here on arrest is the longer you are in police custody, the more likely it is that you are under arrest. And if you are under arrest, you have to have probable cause. So a lot of this stuff depends on what circumstances you're in. So, for example, I was a lawyer with the Texas Highway Patrol back in a while ago. And so I was doing a ride along, and we stopped a lady in a car, and it was pot season. It was back in the 90s. Pot's illegal everywhere. It's still illegal in Texas. Still illegal under federal law. Anyway, he just kind of asked, you can ask, do you mind if I search your vehicle? She said no. And so Mark was going to have to get the dog. Well, to call. So he had problems. So we could kind of catch a slight whiff. There were some other factors. He had a bunch of factors on the car. It was a rental car. It was not in her name. She had a criminal record. There was the trunk was empty, or excuse me, all the luggage was in the back seat and not the trunk, which raises the question, what's in the trunk? She told a couple of lies that showed that she didn't really know where she was going or what she was doing, and she'd been pulled over going like 95 miles an hour. So Mark was going to call the dog, and then so we were about 10 miles outside of town. This is Amarillo, Texas. We were 10 miles about 10 miles west of Amarillo on the 40, and then Wayne, the dog officer that day, he was at home, but he's on call. And so Mark called him, and he says, okay, I'll be out there in like 30 minutes. So by the time Wayne got his uniform on, got the dog in the car, got the car out to the thing, the lady waited about 40 minutes. and that's fine. So it's inconvenient, yes, but the law allows that sort of inconvenience to dispel. So Mark had reasonable suspicions that there might be dope in the car, and probable cause to basically hold her there. So she's not under arrest at that point. She was under arrest when they found 110 pounds of dope in the trunk. But up until then, she was being detained, right? Now, the risk the officers run is the longer she sits there. So if Wayne calls and says, you know what, I'm on vacation and there's no dog officer, and the city police, let's say they don't want to bring their dog out into the country because that's outside their jurisdiction, though it's technically not, then he probably would have just had to let her go, because if you just make her sit there for a while and she's not, you don't have probable cause to force your way into the vehicle, so you get those kinds of things. That's what I mean by no bright line exists. Like, now the easy question is, when are you under arrest? If you get cuffed and told you are under arrest, you're under arrest. Right now, the cop, when he does that, he's supposed to, of course, have probable cause for what you're arrested for. So you might get arrested for DUI, let's say, and then they find the body in the trunk, and then you're charged with murder. So what you're arrested for and what you're charged with don't necessarily have to line up, of course, but they have to have probable cause for the thing that they've arrested you for. So that's the easy line, and this is why these cases don't come up a lot. If you're cuffed and they say you are under arrest, then you are under arrest legally. And at that point, they have to have probable cause. Chesternut case is one of my favorite too. So, on the slides here, I probably need to clear these up, but PO means police officer, PC means probable cause, RS means reasonable suspicion. I probably should have fleshed those things out. The Chesternut case is interesting because the Chesternut is walking down the sidewalk, and he sees the cops. He sees a cop car, and then he turns around, he freaks out, and turns around and just runs the other way. And so the cops in the Chesternut case are like, well, let's just see what happens, right? So they follow him in their car, which they're more than welcome to do. It's in a public place. They're not chasing him necessarily. They're just following him. And so as he's running, then he empties his pockets of these little glassine packets, which of course are filled with dope. And so then while the officer, then they see that, they go, okay, well now so then they chase him. And then the one guy's picking up the packets and goes, these are dope. So then she gets arrested. So the court said that just following somebody is not a seizure. You have the right to walk down the street, so do the police officers. And if they're following you, they can follow you, right? As long as they don't have to have any. Now, if they start following you home into your house, obviously, if they're harassing you, if they say stop and they're forcing you to stop, that means they're exercising their power, authority against you. Then they've got to have reasonable suspicion or probable cause to make you stop. If they just say, hey, can I talk to you? And you say, no, I'm in a hurry, I ain't got time. And you go, okay, then, that's it. Most people are people pleasers and don't really do that. And, that'd be rude, but that's kind of also, how do you know if they have probable cause? If they make you stop and they keep you there, then they better know something. They're supposed to know something. They just can't willy-nilly stop people. Search incident to arrest. Slide 14 is just what it sounds like. Everyone who gets arrested can be searched. So there's a stop and frisk, which is outside, outside the shirt, outside the, this or that. And then once you get arrested, they're going to take your hat off and they're going to check the band. They're going to check your waistband, hands in pockets, hands in jacket, take off your jacket, hands in hoodies. They're going to go around the base, the boots, the belt line, and look for weapons and drugs and all that kind of stuff. So everyone who gets arrested gets a search incident to arrest, which is more thorough than just a pat down. The initial pat down before you're arrested for officer safety is like basically feeling for weapons, and that's it. The search incident to arrest is a fuller search of the arrestee. Again, for officer safety, oftentimes because people have been attacked in cars and at the jail and other things. The Katz case and the Greenwood and the Riley and the Kylo case on slides 15 and 16 all deal with technology. So if you think about in today's world, it would be drones. So there are rules as long as the drone rules are being followed. So if they're however many feet up or whatever, that might depend on the size of the drone, the classification of the drone. If it's a plane, it's got to be 1,000 feet up under FAA rules. If it's a helicopter, it's got to be 400 feet up. They can't look in homes. I would say close your window. If your window is open, people can look in. There's no expectation of privacy. So it might be rude, but it's still not private if the windows are open and all that sort of stuff. So curtains, blinds, covers, those things are all there for privacy, not just for personal privacy, but they also give you legal, more legal privacy for those kinds of things. The plain view doctrine on slide 18 and following is just that. If something's out in plain view, I referenced earlier cops looking in windows in parking lots of cars. That's called plain view. If they walk by your front yard and see a dog that they just saw a poster of that was stolen, and they see that dog staked in your front yard, and it's a golden doodle with a blue collar and a big old tag that says, you know, Bucky or Buffy or whatever, and they just saw that dog is stolen, they see the dog, they can come on the lawn and take the dog and make an arrest on that. Why? Because it's that immediately apparent that dog is seizable, right? Same with a car in the front yard that looks like it's stolen. It's got a license plate and a description and all those kinds of things. The warrantless arrest, that's slide 21 and following. Again, there are ways in which cops can make stops or detentions without warrants. So there are a Terry stop is these sort of stop and frisk, like they have what's called a reasonable suspicion. A reasonable suspicion, which is stated in the Terry case as articulable facts by a police officer based on his experience or her experience, that a crime has occurred, is occurring, or is about to occur. That allows them to temporarily detain somebody, so that's called a stop, to dispel or confirm those suspicions. If they confirm those suspicions, that would then be probable cause to arrest. If they have dispelled those concerns, then the person is free to go and all of that. The frisk, as I mentioned, is usually for officer safety. That depends on what they're detaining somebody from. If they're detaining you briefly, stopping you because they think you've committed an armed robbery, well, if it's an armed robbery, they're going to pat you down for officer safety. If you're legally allowed to have the gun and then they let you go, then you get your gun back, right? If you're allowed to carry. So that would depend on the laws of the state related to concealed carry and open carry and all those kinds of things. The Wren case is pretext stops. Pretext stops is they could have stopped you, not whether they would have stopped you. So in the Wren case, you have two cops, plainclothes cops in an unmarked car making a vehicle stop. Policy-wise, they're not allowed to do that, but law-wise, there's nothing stopping from doing that. Nothing in the vehicle code says cars have to be marked or officers have to be in uniform to make vehicle stops, as a general rule. Atwater case, that lady was arrested for a seatbelt violation, which is usually a fine-only offense. She then refused to comply with officer demands and was then arrested for that, and so they held that. Tennessee versus Garner, again on slide 22, is about use of force. PC there is probable cause. So for deadly force, it's probable cause that the person committed a crime, and then if they are running away, there's the deadly force there is allowable if there's probable cause also that they are armed and dangerous and a continuing danger. So if someone has a gun and they're running away and you know they still have the gun, you can use deadly force to effectuate the arrest. If you see the gun and they throw the gun away and you know they're now unarmed, or you know they're unarmed from the get-go, you can't just shoot them in the back, right? Or anything like that, because that, of course, is, you know, we're not here to just take lives. So that's PC plus, if you will, for deadly force cases. Warrantless arrests for cars. If you're in your car, cars are easier because they're mobile. You can, generally if someone's in a home, you get a warrant. In today's world, some of these cases are a little bit, I think, out of date in the sense that, if you look at Segura and even MacArthur, though I would say in MacArthur, which is a 2001 case, this is slide 23, cell phones and smartphones kind of make these cases a little bit out of date. Like, you can get a hold of somebody pretty quickly, right? Like you just text them or call them, and everyone today has. This isn't like the old days where you've got to call a landline, and if someone's literally down the hall, they may not be there to answer the phone, or those kinds of things. So I'm not saying people don't have to sit on houses and wait for for things to get done, but nowadays, warrants are on computers. They're filled in, they're texted, they're PDF'd, they're emailed, all those kinds of things, and the process is a lot quicker now. Warrantless arrest, you can search incident a car. That's slide 26. The Belton case. The Ross case held that you could search a car with probable cause. So going back to my example where we got the dog, once the dog hits on the trunk of the car for marijuana, then that becomes probable cause to then open the trunk of the car, because the trunk was locked, and we didn't have enough information to just sort of pop the trunk, if you will, and the lady did not give consent. The dog then provides the probable cause. So you have those other things about the case, and then the dog is the cinching case that then allows us to search the car, all the car, with probable cause. Why? Well, by the time you get a warrant, and again, it could be after hours, it could be on the weekend, especially in the 90s, it might take days to get a warrant. So then Mark makes the search. In his report, he lists his probable cause, and then the judge and the first appearance, all that. So there's basically it's this kind of a warrant in reverse that is there. Consent. People can always give consent. So if you're a police officer and you say, "May I search your vehicle?" and they go, "Sure," you can search your vehicle. You can totally fish for that. Most cops don't do that, of course. And you're stopping Ma and Pa Kettle on the way to Grandma's house to Christmas or whatever, you're probably not going to ask them to kind of search your vehicle. But if you say, "May I search your vehicle?" and they go, "Sure," well, then you can search the vehicle. So I was in a couple of ride-alongs where that happened, and that resulted in dope. Sometimes people, I guess they figure you got them, and so they don't want to play, and they don't. Interrogation, this gets into Miranda rules. So Miranda versus Arizona is the key case here. Custodial interrogation. So once you're arrested and before they question you, they must read you their rights. That's the basic holding of Miranda versus Arizona. It held that a police station is inherently coercive, and to make sure that confessions are free and voluntary. So that's kind of the legal standard here. All confessions must be free and voluntary. So the Miranda rules just ensure that confessions are free and voluntary. By reading you your rights and telling you that you have the right to remain silent, the right to an attorney, and if you can't afford one, we'll get one for you. And of course, that anything you say we're just reminding you, hey, by the way, if you talk, this is evidence, right? Then the person can then waive their rights and continue talking. They can call a lawyer, and then of course later on they can waive their rights and continue talking. They can shut up. They have the right to remain silent. So all it does is make sure that when they do confess, and a lot of criminals mostly still confess even after Miranda, then it just ensures that they were aware of their rights. Nowadays they sign off, "I understand my rights, sign this please." Now they're on video and recorded and all that as well. Minnick versus, so that's slide 31. Slide 32, Minnick versus Mississippi basically said that when a person lawyers up, and that it just reiterated or confirmed rather that when Minnick asked for his lawyer, the police were supposed to stop the interrogation until the lawyer gets there. So when they lawyer up, as we say, it stops. Everything stops. Go get the lawyer. Now, if the lawyer tells you, "Hey, if I were you, I would confess and let's make a plea bargain," that's a decision. But when the lawyer is invoked, you get the lawyer, stop the questioning. So then that gets us the right to counsel. That's slide 32 and following. So the case here is Gideon versus Wainwright. So indigent defense. So indigent means too poor to pay for an attorney. How poor is that? Not as poor as you might think, because if you're looking at getting charged with a first-degree murder, you might be looking at $500,000 or $1 million, especially in Southern California, for defense. So I don't know about you. I don't have $500,000 laying around, but they would make you mortgage your house, cash out your retirement, max your credit cards, all those kinds of things before the government's just going to pony up for a defense attorney. But the Wainwright case, or the Gideon case rather, is the case that sets that a bar for the entire country in 1963. And then the role of counsel, slide 34, that's the Strickland case. Strickland deals with an issue called ineffective assistance of counsel. That basically just means your lawyer has to be doing his or her job. If they're not doing their job, and I don't mean like I don't agree with their tactics, but they're like high or drunk or asleep or mentally ill or just grossly incompetent. I don't mean like normally incompetent. I mean grossly incompetent. They are so incompetent that we can't trust the outcome of this trial as being just. So there's a balance between, we don't want to sort of pick apart lawyers for, it's not a beauty pageant necessarily, of course, but they're trying not to second guess lawyers. But if lawyers are just grossly incompetent, we want, of course, the defendant has the right to a fair trial. Part of that is having counsel that knows what they're doing. So that's slide 34, 35, 30 through 37. Nix versus Whiteside just kind of reiterates that. Ferretta versus California on slide 39 just says that you have the right to represent yourself. So that's called pro per in California. Some other states call it pro se. Other due process, DP means due process. So slide 39, you have the defendant has a right to be present. You have the right to a presumption of innocence instruction to the jury. Prosecutors are not, that's Darden versus Wainwright. Prosecutors are not allowed to just start calling the defendant names. Anything from racial slurs to scumbag, idiot. I mean, just, if you become a lawyer, be a professional. Everyone here is made in God's image, even the defendant, and treat them with respect and just make your case, right? You can prove they're a murderer without calling them scumbag, dirtbag, names, all that kind of stuff. Because that'll get you in trouble also, right? It's prejudices the jury. And then the punishment section here, the last section, starting at slide 41, that gets into inmate rights. So 8th Amendment, cruel and unusual punishment. So, for example, all these death penalty cases basically hold that the death penalty itself is not cruel and unusual. In fact, it's explicitly in the Constitution in a sense. In the 5th Amendment, no person shall be deprived of life, liberty, or property without due process of laws, which means the government can take your life. That's the 5th Amendment. The 14th Amendment reiterates that in 1868. No state shall deprive a person of life, liberty, or property. So states can also take someone's life if they follow due process. That doesn't require the death penalty, of course, but it is constitutional, and the Supreme Court has sort of reiterated that in a variety of cases. In terms of inmates and ex-offenders, there's, these issues pop up in visitation, mail, obviously prison searches. In other words, there's no protection. You have no right to privacy in prison like you do in the free world. Everything there is very much limited, right? They have the right to limit your security because prisons are punishment. A person has been sentenced there beyond a reasonable doubt, and they've had their due process rights, and they've waived in many cases their right to liberty and property in those areas. So those are a bunch of just rights there that can be limited. Now the things like, so the other part of that, so for like religions, they have to reasonably accommodate. So in other words, they don't have to build you a Buddhist temple, let's say if you're Buddhist, but they do have to provide access to reasonable opportunity to practice. Now, does that include candles? Probably not. Why? They're not going to let you set a fire in a prison as a general rule, right? So some accommodation, right? Are they going to allow you to have wine for the Eucharist if you're Catholic? Yeah, actually, they have prison kits in some places, which basically, if you like a Baptist church, these little cups with the little cracker and the little grape juice. The prison kits for Catholics, because I believe that having real wine is part of the theology of the Lord's Supper for them. Don't quote me on that, but I think that's the case. Anyway, they allow a little bit. You're not allowed to bring alcohol into prison at all, of course, but these little Eucharist kits are designed for just a little bit, enough for a little swallow, and the wafers, of course, for the Eucharist. So that's an accommodation, right, to that. Why? For the purposes of religious liberty. So they balance the interest of religious liberty of the inmate versus the security issue of prisons, which of course would generally dictate no alcohol or drugs in prison. Medical care, deliberate indifference is the standard there. So if inmates, they've been there a while, they might get heart attacks or heart issues, diabetes, cancer, etc. The state has to provide reasonable medical care. If they don't, and they know a person's sick and they fail to do it, that's called deliberate indifference. That gives rise to lawsuits, which is 42 U.S. Code, Section 1983 there. Anyway, so again, is a very broad, deep issue, the criminal procedure and the Constitution. Like I said, that's the main area where the government and persons come into contact on a regular basis. Whether or not you're a general law-abiding citizen or you have a general criminal propensity, if you just think about the day-to-day life of your average person in the United States.